That night, I got a text from my son. Mom, grab your documents and leave right now while sister is sleeping. I woke my husband and we packed in 10 minutes. But in the kitchen window, I noticed a strange silhouette that was watching. Good day, dear listeners. It's Clara again. I'm glad you're here with me. Please like this video and listen to my story till the end and let me know which city you're listening from. That way I can see how far my story has traveled. I had lived in that house for 31 years. Every corner of it was mine. The creaky third step on the staircase, the smell of old cedar in the hallway closet, the way the afternoon light fell through the kitchen window onto the yellow linoleum I'd chosen myself back in 1993. My husband Ronald had built the back porch with his own hands. He passed in 2019, and after that the house became even more mine, if that's possible. It became the last physical proof that our life together had been real. My name is Dorothy. Dorothy Mae Callahan. I'm 72 years old, and until 18 months ago, I thought I understood my family. I have 2 children. My son Michael lives in Portland with his wife and 2 boys. We talk every Sunday. He is a steady, quiet man, the kind who thinks before he speaks and means what he says. My daughter Karen lives 20 minutes from me in the same suburb of Columbus, Ohio. Karen is 46. She married Derek Holt 11 years ago, and I tried, Lord knows I tried, to love him the way a mother-in-law should. For most of my 70s, life was what I'd call peacefully ordinary. I volunteered at the public library on Tuesday mornings. I kept a vegetable garden in the backyard. I drove myself to doctor's appointments, managed my own finances, paid my bills online, and took no medication stronger than a daily aspirin. My mind was sharp. My body was tired sometimes, but whose isn't at 72? The first sign came so gently, I nearly missed it. It was Karen who suggested about a year and a half ago that I let Derek take a look at my investment accounts. Just to make sure everything's organized, Mom. You know how complicated these things get. I remember sitting across from her at my own kitchen table, drinking coffee from my own mugs and feeling a small, cold pebble form somewhere in my chest. I thanked her and said I had an accountant I trusted. She smiled and changed the subject. But the suggestions kept coming. Could Derek help me with the car insurance renewal? Didn't I think the house was getting to be too much for one person? Had I considered that assisted living communities were actually quite lovely these days? Each question arrived wrapped in sweetness, in concern, in the language of love, and each one left that same cold pebble a little heavier. Then small things began to disappear. A folder of property documents I kept in the desk drawer in Ronald's old study, my spare house key, which I'd always kept on the hook by the back door. One evening, I came home from the library to find Karen in my kitchen. She had a key, of course. I'd given her one years ago for emergencies, and she said she'd just stopped by to drop off soup. The soup was on the counter, but the door to Ronald's study was ajar, and I was almost certain I had closed it that morning. I said nothing. I smiled and thanked her for the soup. But that night, I lay awake and thought about the pebble in my chest, which was no longer small. I called Michael the next Sunday and mentioned, carefully, that Karen seemed very interested in my financial arrangements lately. There was a pause on his end that lasted just a beat too long. Mom, he said, I've been hearing some things. Nothing concrete yet. Just be careful what you sign. What you sign? Why would he say that, unless he had reason to believe someone might ask me to sign something? I started paying closer attention. I noticed that Derek had begun accompanying Karen on every visit, which had never been his habit before. I noticed that they always arrived together and always left together, as if one of them alone could not be trusted to report back accurately. I noticed that Karen had started referring to the house as the property, not in a legal sense, just casually, in conversation, the way you'd refer to something that didn't quite belong to anyone in particular. And then came the night that changed everything. It was a Tuesday in March, just past midnight. I had been asleep for 2 hours when my phone lit up on the nightstand. A text from Michael, all capitals. The kind of message that punches through sleep like cold water. Mom, get your documents and leave now. Before Karen wakes up, I'll explain everything. Please. I read it 3 times. My hands were steady. I surprised myself with that. I got up, put on my robe, and went to wake Harold, my companion of 2 years, who slept in the guest room at the end of the hall. Harold is 75, a retired school teacher, and not a man who panics. I told him we needed to leave. He asked no questions. He got up and dressed. I went to the study for my documents box. Deed, will, financial records, social security card, everything. And that was when I passed the kitchen. The kitchen light was off. The window above the sink faced the side yard, and through it, in the pale blue dark, I saw a shape, a silhouette. Someone standing in the yard, still, facing the house, facing the kitchen window, facing me. I did not scream. I pulled back from the window, pressed my back against the refrigerator, and stood there in the dark with my documents box held against my chest like a shield. Who was standing in my yard at midnight? And why, in that moment, did I already know the answer? Harold appeared in the kitchen doorway 30 seconds later, car keys already in his hand. I pointed at the window. He looked. The silhouette was still there, motionless, patient, as if it had all the time in the world. Harold took me by the elbow, and we went out through the front door, not the back. My car was in the driveway. I got in, Harold drove, and we were 2 blocks away before either of us spoke. "Who was that?" Harold said. "I don't know," I said. And then, because I have never been a woman who lies to herself for comfort, I think I do know. We drove to the Extended Stay America on Henderson Road, the kind of place that asks no questions and takes cash. I had cash in the documents box. $240, money I'd started keeping there 3 weeks ago without fully admitting to myself why. Harold paid for 2 nights. We went upstairs. I sat on the edge of the bed and did not sleep again until 4 in the morning. When I woke, it was full daylight. Harold had gone to the lobby for coffee. I sat up, opened the documents box on the small desk by the window, and began to take stock. The deed to the house was there. My will, Ronald's and mine, updated in 2021, was there. My financial account statements, printed and folded, were there. My Medicare card, my Social Security card, my passport, all there. I had been lucky, or I had been quietly, unconsciously preparing, which is a different thing entirely and far more unsettling to consider. What was not there was the feeling that my home was still my home. I thought about the folder of property documents that had gone missing from the study. I thought about Michael's words, "Be careful what you sign." And I thought about the silhouette in the yard. And I began, slowly and with great reluctance, to assemble a picture I had been refusing to see clearly for months. Karen and Derek wanted the house. Not eventually, not as inheritance, not through any patient and legitimate process. But now, while I was still alive, through whatever means were available to them. The kindest interpretation was that they believed I was declining and needed managing. The honest interpretation was that they had decided my autonomy was an inconvenience to their financial plans. I called Michael at 7:30. He answered on the first ring. He had, it turned out, been sitting on this knowledge for 6 weeks. A friend of his, a woman who worked in a Columbus law office, had mentioned in passing that a couple matching Karen and Derek's description had inquired, preliminarily, unofficially, about the process for petitioning a court to declare an elderly parent legally incapacitated. The grounds they had discussed included cognitive decline and inability to manage financial affairs. The friend, knowing Michael's family was in Columbus, had put the pieces together and called him. Cognitive decline. I, who had completed the New York Times crossword that very Tuesday morning. I sat in that beige hotel room and let the full weight of it settle onto me. This was not a misunderstanding. This was not Karen being overprotective in a clumsy way. This was a legal strategy, researched and considered, designed to strip me of my autonomy and through that, my assets, my house, Ronald's house. 31 years of a life. The grief came first. I won't pretend it didn't. Karen was my daughter. I had held her when she was an hour old. I had driven her to school and sat through her school plays and helped her move 3 times and lent her money twice and never asked for it back. Whatever she had become, or whatever Derek had made of her, she had once been mine in the most fundamental way a person can belong to another. I gave myself 20 minutes for grief. I sat by the window and cried quietly, and Harold put his hand over mine and said nothing, which was exactly right. Then I dried my face and I thought, what did I have? I had my documents. I had a sound mind. I had Michael. I had Harold. I had, most importantly, time. Because Karen and Derek did not yet know that I knew. They thought I had fled in panic. They did not know I had fled with purpose. What did I need? I needed a lawyer. Not just any lawyer. An elder law attorney. Someone who specialized in exactly this kind of predatory guardianship scheme. I needed to move my financial accounts before any petition could be filed. I needed to document everything I could remember. The missing folder, the questions about assisted living, the comments about the property, the silhouette in the yard. And I needed to do all of this quietly, before Karen and Derek realized that the woman they had dismissed as a confused old widow was, in fact, paying very close attention. I took a notepad from the desk drawer and began to write. Names, dates, incidents, the folder, the key, the study door left ajar, Michael's warning, the text message at midnight, the figure in the yard. I wrote for an hour without stopping, in the neat, careful handwriting of a woman who had once taught Sunday school and knew the value of a clear record. When I finished, I looked at what I had produced. 3 pages of notes. 3 pages of a story that, told to the right person, in the right room, would be very difficult to dismiss. I was 72 years old. I had survived the death of my husband, a cancer scare in 2015, and 31 Ohio winters. I had raised 2 children mostly on my own, while Ronald worked double shifts at the plant. I was not going to lose my home to a man I had never fully trusted, and a daughter who had, somewhere along the way, stopped being mine. I picked up my phone and searched, Elder Law Attorney, Columbus, Ohio. The fight had begun. The office of Patricia Nguyen, attorney at law, was on the 14th floor of a glass building downtown, with a view of the Scioto River and a waiting room that smelled of fresh coffee and calm competence. I had called that same morning from the hotel and been given an appointment for the following day when a cancellation had opened a slot. I took it as a sign, not a supernatural one, just the ordinary kind, where the world briefly cooperates with a decision you've made correctly. Harold drove me. He waited in the lobby with a paperback while I went upstairs alone. I had worn my good blue coat and brought my notepad and the documents box. I wanted Patricia Nguyen to see a woman who was organized and clear-eyed, because that is what I was. She was younger than I expected. Early 40s, Vietnamese American, with reading glasses pushed up on her head and the focused, unhurried manner of someone who had heard difficult stories before and knew how to sit with them. She did not rush me. She let me tell the whole thing from the beginning, and she took notes, and when I finished, she was quiet for a moment. "Mrs. Callahan," she said, "what you're describing has a name. It's called predatory guardianship, and it's more common than most people realize. Adult children, sometimes genuinely believing they're helping, sometimes not, pursue legal incapacitation of a parent in order to gain control of their finances and property. The process is initiated through the probate court. If a petition is filed and a guardian is appointed, you could lose the right to make your own financial and medical decisions. She paused. The good news is that you came to me before any petition was filed. That matters enormously. We spent 2 hours together. By the end of that meeting, I had retained her formally, paid a retainer from the cash in my documents box, and we had outlined 3 immediate actions. First, I would move my primary checking and savings accounts to a new bank, with no connection to any accounts Karen might have visibility into. Second, I would update my power of attorney documents to name Michael as my sole agent, revoking any previous informal arrangements. Third, Patricia would send a certified letter to Karen and Derek on firm letterhead, informing them that I was represented by counsel and that any further contact regarding my finances, property, or living arrangements should be directed to her office. That letter, Patricia explained, would do 2 things. It would create a legal record, and it would tell Karen and Derek that I knew. "Are you prepared for their reaction?" she asked. "Yes," I said. I had been preparing for it since 4 in the morning. I left the building feeling something I hadn't felt in weeks, solid, like I had weight again, and the weight was mine. The reaction came faster than I expected. I had not yet returned to the hotel when my phone rang. Karen. I let it go to voicemail. She called again. Voicemail. Then a text. "Mom, where are you? I came by the house and you're not there. I'm worried." Then another. "Please call me. This is not like you." Then, 20 minutes later, one that dropped the pretense entirely. "Mom, I know you talked to Michael. Whatever he told you is not the whole story. Please don't do anything drastic. Don't do anything drastic." There it was. The language of someone who already knew what drastic might look like and was afraid of it. I showed the texts to Harold. He read them without expression and handed my phone back. The certified letter went out the next morning. Patricia called me that afternoon to confirm it had been sent. By evening, Michael called me to say that Derek had called him. Not Karen, Derek. And had been, in Michael's words, very controlled, but very angry. Derek had said that I was confused and acting out of fear, and that the family needed to sit down together and have a conversation before lawyers got involved. Michael had told him, politely and firmly, that the lawyers were already involved. Derek had hung up without saying goodbye. I slept better that night than I had in months. But the following afternoon, Patricia called me with something that turned the situation from a family dispute into something with sharper edges. One of her paralegals, cross-referencing public court records as a standard precaution, had found it. A preliminary filing submitted to the Franklin County Probate Court 9 days earlier, initiating an inquiry into the competency of one Dorothy Mae Callahan, age 72, of Columbus, Ohio. The petitioners were listed as Karen Lynn Holt and Derek James Holt. They had already started. I sat in the hotel room and held my phone against my chest after Patricia told me, and I looked at the water stain on the ceiling, and I thought about the 31 years in that house, and the yellow linoleum, and Ronald's porch, and the vegetable garden no one was watering. 9 days ago. They had filed 9 days ago, while Karen was still bringing me soup and asking if I'd considered assisted living. While she was standing in my kitchen with her warm smile, the paperwork was already in the courthouse. This was no longer a suspicion. This was documented. This was real. And now that it was real, there was no version of this story in which I could afford to hesitate, doubt myself, or soften my position out of love for a woman who had already, quietly, begun the legal process of erasing me. I called Patricia back within the hour. "We fight," I said. "Yes," she said, "we do. The plan Patricia and I had outlined moved forward with a precision that felt, in retrospect, almost surgical. Within 48 hours of that phone call, I had opened a new checking account at a credit union across town, one Karen had no knowledge of, and transferred my primary savings into it. My brokerage account, held at Fidelity, was secured with new login credentials and a security freeze on any changes to beneficiaries. Michael, via notarized paperwork Patricia prepared and I signed, became my sole power of attorney for both financial and medical decisions. My existing will was reviewed, confirmed intact, and registered with Patricia's office as a precautionary record. In practical terms, if Karen and Derek had hoped to find a woman whose affairs were easy to access, they now found a locked door. Patricia filed a formal response to the probate court inquiry, documenting my cognitive fitness with a letter from my primary care physician, Dr. Alan Marsh, who had examined me annually for 12 years and was, to put it mildly, surprised and professionally offended to learn that anyone had suggested his patient was incompetent. He wrote 3 paragraphs. They were not gentle. I was grateful to him in a way that was hard to put into words. She also submitted my 3 pages of handwritten notes as a supporting exhibit, alongside Michael's written statement and the sequence of text messages from Karen on the night I left. Then we waited. We did not wait long. Karen came to the hotel. I do not know to this day how she found out where I was staying. Perhaps she had called hotels. Perhaps Derek had some method I preferred not to think about. It was a Thursday evening, 4 days after the certified letter had been delivered, and I was sitting with Harold watching the local news when my phone rang. Not Karen's number, but the hotel's front desk. The clerk said there was a woman in the lobby asking for me by name. I told the clerk I was not accepting visitors and asked that the woman be asked to leave. 30 seconds later, my cell phone rang. Karen. I answered it this time because Patricia had told me to document direct contact, and because I had decided I was not going to spend the rest of this process hiding. Mom! Her voice was tight, stretched thin over something that was trying very hard not to sound like fury. Mom, please come down. We need to talk. This has gone too far. Karen, I said, you can speak to my attorney. I don't want to speak to your attorney. I want to speak to my mother. A pause. Then lower. Derek and I can make this very difficult for you. Do you understand that? We can tie this up in court for years. We can make Michael look like he's manipulating you. We can bring in our own doctors. All we want is a conversation. There it was. The sweetness was gone entirely. What was underneath it was not a daughter worried about her mother. What was underneath it was a threat. Then you'll speak to my attorney, I said, because that's how people who file court petitions against their mothers communicate. And I ended the call. My hands were shaking slightly when I put the phone down. Harold handed me a glass of water without a word. I texted Patricia the summary of the call immediately, time-stamped. She replied within 10 minutes, "Perfect. Do not engage further. This is exactly what we need." Karen did not leave the hotel lobby quickly. The front desk called twice more. I did not go down. After 40 minutes, she left. The following morning, things escalated in a direction I had not fully anticipated. Derek called Michael. This time not controlled, not careful. Angry in the open, unguarded way of a man who has realized that his plan is failing and is looking for something to break. He told Michael that I was being manipulated by a predatory attorney who was exploiting a vulnerable elderly woman for fees. He said that Michael had poisoned my relationship with my daughter out of his own financial self-interest. He said that if Michael did not convince me to drop the attorney and return home within the week, they would amend their court filing to include allegations of elder financial abuse by Michael. Michael called me immediately after, and I could hear in his voice something I had never heard there before. Genuine fear. "Mom, they're going to lie. They'll say I'm the one taking advantage of you." "I know," I said. And they won't be believed because we have a record, and they don't. I called Patricia. She was unsurprised. They're panicking, she said. Threatening counter-allegations at this stage is a sign of weakness, not strength. Let them file whatever they want. Every move they make creates more evidence of bad faith. I believed her. I also knew that belief and calm are not the same thing, and that even the strongest people require rest. After the paperwork was filed, after the accounts were secured, after Patricia had the situation under active management, I allowed myself 4 days. Harold and I moved from the extended stay to a small inn outside of town, the kind with a porch and a garden, and no history. I called my friend Betty Morrison, who had known me since Ronald was alive, and told her everything. Betty was not a woman who panicked either. She brought a casserole to the inn on Saturday and sat with me for 3 hours, and we talked about everything and nothing, and it was the first time in weeks that I felt like Dorothy Callahan, the person, rather than Dorothy Callahan, the legal matter. I needed that. I needed to remember who I was outside of the fight, but I knew, resting on that porch in the early spring air, that the fight was not close to over. The offer came on a Tuesday morning, delivered not by Karen but by a man I'd never met, a lawyer named Gordon Price, who called my cell phone and introduced himself as representing the Holt family in a private capacity. I sat very still on the porch of the inn and listened. Mr. Price was smooth in the practiced way of a man who delivers uncomfortable proposals for a living. He said that Karen and Derek were deeply distressed by the adversarial direction the situation had taken, and that they remained committed to Dorothy's well-being and long-term care. They wished, he said, to propose a resolution outside of court proceedings. The terms, as he outlined them, were these. I would agree to a voluntary financial management arrangement in which a neutral third-party trustee, one pre-approved by Karen and Derek, would oversee my accounts and major expenditures. In exchange, Karen and Derek would withdraw the probate court petition entirely. I would keep my house. I would keep my name on the deed. I would simply no longer control my own money. Mrs. Callahan, Mr. Price said, with the warm tone of someone offering a gift, this arrangement would protect you from any future financial missteps and would give your family the peace of mind that— Mr. Price, I said, I am going to stop you there. I was not angry. I want to be clear about that. I was not shaking the way I had been in the hotel room when Karen called. I was sitting in a chair on a porch in the April sunshine, and I was 72 years old, and I had spent the last 4 days remembering who I was, and I felt, in that moment, entirely clear. Please tell your clients, I said, that I will not be accepting any arrangement that places my finances under the control of people who filed a competency petition against me. Please also tell them that this phone call has been noted and will be reported to my attorney. Have a good morning. I hung up. I called Patricia within 5 minutes. She was, I thought I could hear, quietly pleased. A trustee pre-approved by them is not a neutral trustee, she said. That's a rebranding of exactly what they were already trying to do through the court. You answered correctly. I know, I said. That afternoon, I took a long walk around the inn's grounds, along a path that ran beside a small creek. The trees were just beginning to come in, that particular pale green of early April that always made Ronald quote something from Whitman he half remembered. I walked for an hour and thought about very little except the sound of the water. What I had discovered in those 4 days was that I was not alone in the way I had feared I might be. Michael called every day. He had spoken to 2 colleagues at his firm who had experience with elder law cases and had helped Patricia understand some procedural nuances on the Oregon side that weren't relevant to Ohio, but gave her, she said, useful context. He had also, quietly and without being asked, begun keeping a log of every communication Derek made to him. Dates, times, summaries, on the advice of one of those colleagues. Betty Morrison had, without my asking, reached out to two other women in our Tuesday Library volunteer group, both of whom had lawyers in their families. One of them, a woman named Grace Chen, had a daughter who was a social worker specializing in elder abuse cases. Grace asked if I would be willing to speak with her daughter. I said yes. Her daughter's name was Amy, and she met me at a coffee shop in town on Thursday afternoon. She was 34, brisk and warm, and she had seen this kind of case before. Not uncommonly, she said, which broke something in me a little to hear. She explained that there was a formal avenue I hadn't fully considered. Beyond the legal defense, I could file a report with Adult Protective Services documenting the attempted financial exploitation. Such a report would not only be part of a public record but would be investigated independently, separate from Patricia's case, by a state agency with its own authority. It strengthens everything, Amy said. It shows a pattern, and it means two separate official bodies are looking at what they did. I filed the report that Friday. Karen and Derek did not call that week. Mr. Price did not call again. But Michael mentioned, offhandedly, that Derek had been asking around, through mutual acquaintances in Columbus, people who knew me, about who I was spending time with, where I was staying, whether I had seemed confused to anyone recently. They were gathering, watching, waiting for a crack to appear. I thought about the silhouette in my yard in the dark, that patient, still figure, and I understood now what it represented. Not menace exactly, but surveillance. The belief that if you watched a person long enough, they would eventually give you what you needed. They were going to be waiting a long time. I had Betty and Michael and Harold and Amy and Patricia and Dr. Marsh's letter and 3 pages of handwritten notes and a report filed with the state of Ohio. I had, in other words, more people in my corner than Karen and Derek had apparently accounted for when they'd decided I was a manageable problem. I ordered a second cup of coffee and watched the creek behind the inn and thought, let them watch. Karen came to see me without calling first. It was a Saturday afternoon, nearly 3 weeks after I'd left the house, and I had returned to my own home that week. Patricia had confirmed it was both legally and practically safe to do so, and I had changed the locks the same day I moved back in, with a locksmith Harold had recommended. The new keys were 2, one for me, one for Michael, who had driven down from Portland for the weekend, specifically to be present during the transition. Michael was in the backyard repairing a section of fence when Karen's car pulled into the driveway. I saw it from the kitchen window and felt my stomach tighten, not with fear, but with the particular tension of someone who has been preparing for a confrontation and now watches it arrive. She came alone. That surprised me. She knocked, which was new. I opened the door. She looked tired. I will say that honestly. She looked as though she hadn't been sleeping well, and some part of me, a very old part, wanted to respond to that. She was my daughter. I remembered her tired face from when her children were small, and from when her first marriage fell apart, and from every hard year she'd brought to my kitchen table. The love doesn't leave. It just has to learn to stand aside. "Mom," she said, "can I come in?" I looked at her for a moment. "You can sit on the porch," I said. I did not offer coffee. I sat in the chair across from her and folded my hands in my lap and waited. She began with an apology. It came out structured and careful, the way a speech comes out when it has been practiced, and it covered the misunderstanding about the court filing, which she described as Derek's idea that she had gone along with out of genuine worry. She said she had never intended to hurt me. She said she missed me. She said that she and Derek just wanted to know I was safe, that the house wasn't too much, that I had support. I listened to all of it without speaking. Then she said, "Mom, if you just drop the attorney, Patricia, whatever her name is, and let us sit down as a family, we can work this out." Michael doesn't need to be involved. This should be between you and me. Derek has some ideas about— Karen, I said, stop. She stopped. You filed a legal petition to have me declared incompetent, I said. Not as a misunderstanding. Not as Derek's idea that you were dragged along with. You signed that document. Your name is on it in a courthouse right now. That is a fact, and no conversation at this table undoes it. Her face shifted. The tiredness didn't leave, but something underneath it hardened. Mom, you are not being reasonable. You've been influenced by Michael and some attorney who is charging you money to— I've been influenced, I said, by the fact that you filed a court petition against me. We were worried about you. Her voice rose. You're alone in this house. You're 72. Anything could happen. Then come for Sunday dinner, I said. Call me when you're in the neighborhood. That is how a worried daughter behaves. A worried daughter does not consult a probate attorney. Silence. She looked at me, and I looked at her, and in the space between us was everything that was not being said. The house, the money, Derek waiting at home for her report. The years between us that had carried us to this porch. Then she said very quietly, if you keep fighting this, you are going to lose your relationship with me entirely. Is that what you want? There it was. The mask was fully gone now, the final instrument in the toolkit, not law, not persuasion, but the oldest threat a child can make to a mother. I will leave you. I will become a stranger. Is that what you want? I felt something in my chest then, and I want to be honest about what it was. It was fear. A real, specific fear. Not of Karen, not of Derek, but of the particular silence that lives in a house where a child has stopped calling. I knew that silence already, in smaller forms. I was not casual about it. But I also knew, with the clarity that had been building in me for weeks, that I could not buy her presence with my surrender, that a relationship rebuilt on my capitulation was not a relationship. It was a management arrangement with warmer language. Karen, I said, if you walk away from me because I hired an attorney to protect my home from a court filing, then that is your choice, and I will grieve it. But I will not trade my house for your phone calls. She stood up. Her hands were tight at her sides. You'll regret this, she said. Not as a threat, or perhaps as both. She walked to her car. She didn't look back. I sat on the porch after she left and looked at Ronald's garden, still coming up without anyone tending it properly. The peonies he'd planted along the fence just beginning to bud. I was afraid. I'm not going to dress it up. The possibility of losing Karen entirely, not to a court, not to a legal ruling, but simply to her own choice, sat in me like something heavy and cold. But the fear clarified something rather than dissolving it. I thought of the silhouette in the yard. I thought of the folder that had gone missing. I thought of the word property used in my own kitchen. I thought of 9 days. The 9 days between Karen's soup visit and the court filing. The fear burned down, and what was underneath it was not grief. It was the cleanest, steadiest anger I had ever felt. Michael appeared at the corner of the house. He had seen Karen leave. He looked at me. You okay? He said. Yes, I said. Go call Patricia. I want to be in court before they change their strategy again. The hearing was scheduled for a Wednesday morning in late April in courtroom 4B of the Franklin County Probate Court. Patricia had spent the preceding 2 weeks in a preparation I can only describe as quiet and absolute. She had deposed Dr. Marsh, whose written letter had already been entered into evidence, but whose live testimony, she felt, would carry particular weight. She had organized the Adult Protective Services report, which had concluded its preliminary review and found credible indicators of attempted financial exploitation. She had arranged for Amy Chen to submit a professional declaration in her capacity as a licensed social worker. And she had compiled the text messages, the time-stamped notes, the the call log Michael had maintained, and the recording, which I had made legally under Ohio's one-party consent law, of Karen's visit to the porch the previous Saturday. Karen had said on that recording, "If you keep fighting this, you are going to lose your relationship with me entirely." Recorded, time-stamped, entered into evidence as Exhibit F. I wore my blue coat again. I sat beside Patricia at the respondents' table, and I looked at my daughter across the room and felt, more than anything, tired. Not defeated, not frightened, but the tiredness that comes from having carried something heavy for a very long time and being nearly at the place where you can set it down. Derek sat beside Karen. He was wearing a suit that was slightly too good for the occasion, the kind of choice that suggests someone trying to project authority rather than simply possessing it. Their attorney, Gordon Price, sat on their left. He looked, I thought, less comfortable than he had sounded on the phone. The judge was a woman named the Honorable Sandra Okafor, and she had the kind of face that suggested she had heard many stories and was not easily moved by any of them. She was moved by ours. Patricia opened by establishing the timeline. The court petition had been filed 9 days after Karen had visited my home with soup. 9 days during which I had shown no signs of cognitive decline documented by any medical professional. 9 days during which I had managed my own finances, driven myself to appointments, and engaged in normal daily activity. She then called Dr. Marsh. Dr. Marsh was 61 and had the direct manner of someone who had no patience for implications he found professionally insulting. He stated, without qualification, that I was cognitively intact, that my annual cognitive assessments showed no decline, and that the suggestion of incompetence was, in his medical opinion, unsupported by any clinical evidence he had ever observed. Gordon Price cross-examined. He asked whether it was possible for cognitive decline to be present without clinical detection. Dr. Marsh said it was theoretically possible, but that in this specific case, with this specific patient, he saw no basis for the claim. Price pressed. Marsh held. He was not a man who bent under polite pressure. Then Patricia called me. I had been prepared for this, and I was not nervous. I answered her questions clearly and factually. I managed my own accounts. I had updated my will. I had retained counsel. I had filed a report with the state. I described the missing folder, the conversation about the property, the midnight text from Michael, the figure in the yard. When Price cross-examined me, he tried a softer approach, suggesting that perhaps I had been frightened into an adversarial position by Michael's influence, that perhaps I wasn't seeing the situation clearly. I looked at him and I said, "Mr. Price, I am the woman who noticed the missing folder, made notes for 3 weeks, retained an attorney, secured my accounts, filed a state report, changed my locks, and came to this courtroom today. Does that sound like a woman who isn't seeing clearly?" There was a small sound in the room. Judge Okafor did not smile, exactly, but something in her expression acknowledged it. Then came the moment I had not anticipated, which turned out to be the moment that mattered most. Patricia called Derek. He was not happy about it, but he had no choice. He had submitted a declaration in support of the petition, which made him a relevant witness. He took the stand with the contained, careful composure of a man who believed he could manage this. Patricia asked him directly and without preamble when he had first contacted a probate attorney about his mother-in-law. He said, 8 months ago. 8 months. At a time when Karen was still bringing me soup and asking casually about my finances. 8 months before any alleged concern about my cognitive state had been raised with me directly or with any medical professional. Patricia paused. Let the number sit in the room. "Mr. Holt," she said, "did you at any time communicate to Mrs. Callahan that you believed she might benefit from a professional assessment of her cognitive function?" A pause. "We discussed it informally. Did you suggest she speak to her doctor?" Another pause. Longer. "I believe the topic came up. Did you contact her doctor directly?" No. Did you, at any point in the 8 months between your first consultation with a probate attorney and the filing of this petition, suggest to Mrs. Callahan that you had legal concerns about her capacity? Derek looked at Karen. Karen looked at the table. We felt that raising it directly might upset her, he said. Patricia let that sentence stand in the room for a moment that felt, to me, like a full minute. You were concerned about upsetting her, she said, but not concerned enough to forego filing a court petition declaring her incompetent. Gordon Price objected. Judge Okafor allowed it. Then Patricia presented Exhibit G phone records, obtained through discovery, showing a call between Derek's cell phone and an unknown number on the night I had left the house. The unknown number was traced, in the records Patricia had subpoenaed, to a private individual, a neighbor of Karen and Derek's, who had, according to his own statement, when contacted by Patricia's investigator, been asked by Derek to drive by Dorothy's house and see if she was home on the night in question. The silhouette in the yard had a name. It was a man named Kevin Prater, 38, who lived 4 houses down from Karen and Derek, and who had, apparently without fully understanding what he was participating in, stood in my yard in the dark at midnight because Derek had asked him to. Derek had sent someone to watch my house while he waited for me to run. The room was very quiet. Judge Okafor looked at the Holts for a long moment. Then she looked at me. I sat with my hands folded on the table, and I said nothing because there was nothing left to say. The record said everything. Judge Okafor did not take long. She recessed for 40 minutes, during which Patricia and I sat in a small room off the hallway with coffee we didn't drink, and Harold, who had been in the gallery, came to find me and held my hand without speaking. Michael had not been able to attend in person. There had been a work emergency in Portland. But he had sent a text that morning that said simply, "I'm with you today, Mom." I had it on my phone in my coat pocket. When we returned to the courtroom, Judge Okafor delivered her ruling in the flat, precise language of someone who has made a clear decision and sees no reason to soften it. The petition for a determination of incapacity regarding Dorothy May Callahan was dismissed, not continued, not returned for further evidence. Dismissed. The judge found the petition to be not only without medical or factual foundation, but, in her words, contrary to the evidence in a manner that raises serious questions about the petitioner's motivations. She noted the 8-month gap between Derek's first consultation with a probate attorney and any direct communication with me. She noted the Adult Protective Service's preliminary finding. She noted the coordinated surveillance of my residence on the night I left. She noted specifically that the petitioners had never sought an independent medical evaluation of my condition prior to filing, that, in other words, the legal process had been initiated not to protect me, but to control me. She referred the matter to the Franklin County Prosecutor's Office for review of potential elder financial abuse charges. Then she looked at Gordon Price and said, "Counsel should be aware that the court takes a serious view of petitions of this nature filed without adequate evidentiary foundation. You may wish to advise your clients accordingly." Price nodded. He looked like a man calculating the distance between himself and a problem he had agreed to represent. Karen and Derek left the courtroom quickly. I watched them go. Derek had his hand at Karen's back. Not tenderly, I thought, but the way you guide someone who is walking unsteadily. Karen did not look at me. Outside, on the courthouse steps in the April sunshine, Patricia shook my hand with both of hers and said, "You were remarkable in there." I was honest, I said. "It's not the same thing, but it helps." Harold brought the car around. Michael called within minutes of the ruling. Patricia had texted him. And I could hear something in his voice that took me a moment to identify. It was relief, the kind that accumulates over months of held breath. "Mom," he said, and couldn't finish the sentence. And I told him it was all right, that it was done, that he could breathe. The legal consequences for Karen and Derek unfolded over the following months with the slow, grinding consistency of institutional process. The Franklin County Prosecutor's Office did open an investigation. The charges ultimately filed were two: attempted financial exploitation of a vulnerable adult under Ohio Revised Code 2913.02 and filing a false statement in a legal proceeding. Specifically, the representation in their petition that I exhibited signs of cognitive decline that had been documented by a medical professional, which Dr. Marsh's testimony and records had clearly established was not true. Derek, as the primary architect of the scheme, faced the more serious exposure. Karen, who had signed the petition, faced lesser charges as a secondary participant. Their own attorney, Gordon Price, withdrew from representation after the prosecutor's inquiry began. They hired a criminal defense attorney. The process was long and expensive. The Adult Protective Services case remained open as a parallel record, independent of the criminal matter. The civil consequence came through Patricia as well. I filed suit against both Karen and Derek for the legal costs I had incurred in defending against their petition. Ohio law provides for this in cases where a guardianship petition is found to be without reasonable basis. The suit settled out of court, not because I was willing to compromise on the principle, but because Patricia advised me that a settlement on our terms, with a full admission of the lack of factual basis for the original filing, was a better outcome than a prolonged civil trial. I agreed. The terms required them to pay my legal fees in full and to sign a document acknowledging that I was, and had been at all times, a competent adult fully capable of managing her own affairs. Karen signed it. I don't know what that cost her or what kind of conversation happened in their house the night before they signed. I thought about it once, and then I put it away. I changed the locks again, not out of fear, but out of formality. A clean demarcation. I took Karen's name off the emergency contact list at my doctor's office and replaced it with Michael's. I updated my will to reflect the reality of what had happened, not out of punishment, but out of accuracy. It had always been the most important document in the house, and then I went home. Truly home, in a way I hadn't felt since the folder went missing. And I sat on Ronald's porch in the evening, with Harold beside me and the garden beginning to properly come in, and I let the whole thing be over. It was over. I had not lost my house. I had not lost my name. I had not been erased. The summer that followed was the most ordinary one I could have asked for, and I mean that as the highest possible praise. I planted tomatoes where the peonies had gotten crowded and needed thinning. I went back to the library on Tuesday mornings, where Grace Chen had told everyone a version of the story that was both accurate and, I felt, slightly more heroic than I deserved. I didn't correct her. I accepted the casseroles and the embraces of women who had known me for decades and who were, I understood now, part of the support system I had always had, but perhaps never fully valued. Michael came down from Portland in June with his wife Jenny and their boys. We sat on the back porch every evening and ate badly and talked well. His older boy, Nathan, he's 12, wanted to know everything about the court case in the way 12-year-olds want to know about battles. I told him the abbreviated version, and he said, "Grandma, you won," with such simple admiration that I had to look away for a moment. I did win. I am not ashamed to say so plainly. Harold and I formalized our arrangement that fall. Not marriage. We were both past the drama of that, but a legal partnership agreement that Patricia helped us draft, ensuring clarity for both our estates. It was, I thought, the most romantic thing I had done in years. Betty Morrison organized a small celebration in November at her house. The library group, Amy Chen and her mother Grace, Harold, and Michael and Jenny over the phone from Portland. We ate too much and laughed at things that had not been funny at the time, and that were still not entirely funny, but could now be held with a lighter grip. I am not going to claim that the loss of Karen doesn't hurt. It does. She is my daughter, and those facts don't dissolve because of what she did or what the court decided. I sent her a card at Christmas. Simple, not warm, not cold. A marker. She did not reply. Perhaps someday she will. I have learned at 72 that I cannot control what other people choose, only what I do with those choices. As for Karen and Derek, by the following spring, Derek had accepted a plea agreement, a conviction on a reduced charge of attempted exploitation of a vulnerable adult, with probation, community service, and a formal prohibition on serving in any fiduciary capacity. Karen received a conditional discharge, provided she completed supervision and paid her share of my legal costs. What I heard through the reliable telegraph of a small suburban community was this: Derek and Karen sold their house within 18 months of the hearing. The legal fees, combined with the settlement payment and criminal defense costs, had significantly damaged their finances. They moved to a smaller rental across town. Derek lost his position at the financial consulting firm. His employer had become aware of the nature of the case and found it incompatible with a role that required managing other people's money. There is a word for what happened to them, and that word is consequences. Not catastrophe, not ruin, just the steady, unglamorous weight of having done a thing that was both wrong and poorly thought out. I did not gloat. Every morning when I woke up in my house, in the bed I had chosen, in the room with the window I liked, I had all the satisfaction I required. Ronald's porch is still standing. I had it properly repaired in August. Harold and Michael spent a weekend on it, and I brought them lemonade. The new boards are a slightly different shade, and I like that. It means the porch is continuing to be itself, absorbing time, changing without losing its shape. I am 72 years old. I know what I own, and I know who I am. And I have around me people who would stand on a porch with me in the dark if I needed them. What more could anyone want? That's the whole story. And here is what I know now. Your name on a document is your power. Trust is not the same as love. Write things down before you have a reason to. Know where your documents are tonight, not someday. When something small goes missing, a folder, a key, a question asked too casually, pay attention. That is where it begins. If you had been standing in that dark kitchen, holding your deed to your chest, what would you have done? I hope you would have walked out the front door and started fighting. If this story meant something to you, please share it and leave a comment below. Thank you for being here with me today.